Artificial intelligence giant OpenAI recently argued in an Ontario court that a copyright lawsuit filed by Canadian news publishers over its ChatGPT AI system should be heard in the US and not in Canada. OpenAI argued that the activity happened outside of Ontario and Canadian copyright law shouldn't apply, while the news publishers argue the content was created in Canada and that there is a real and substantial connection to the province. We spoke with Peter Heinen, one of Canada's leading criminal defense lawyers, to discuss how strong OpenAI's argument is that this case belongs in a US courtroom and what factors a judge could weigh in deciding that.
So the law on when an Ontario court can take jurisdiction versus when jurisdiction is not proper is a multifaceted one. It requires the court to look at a number of different elements. So it's very hard. I haven't reviewed the OpenAI brief, so I don't know all of the arguments that they're raising, but the thrust of it is, as I understand, is that they're based in San Francisco. The so-called infringement, they would say, is happening outside of the country, and therefore you can't take jurisdiction. But the test is basically that the court looks at where the defendant is domiciled. So in this case, San Francisco. Do they carry on business in Ontario? In this case, I would argue that they carry business. They carry on business across Canada. Where was the wrongdoing or the tort committed? And in this case, we would say it's happening in Canada, in Ontario. And was there some sort of contract connected with the jurisdiction? So did they enter into the parties enter into a contract that somehow ties it to Ontario? And so, that might require the court to look at the terms of use and whether or not there's an agreement being entered into. But in the case of scraping online resources, there is no agreement, just because that's a non-consensual act, which is really the basis of the lawsuit. And so the kinds of issues from a copyright perspective that the court is going to look at are questions like, where are the servers located? Because when you're talking about online infringement, the question is, where is it happening? And, this is a question that I think our courts are going to be very careful at looking at because they really need to try and protect the Canadian digital marketplace.
We also discussed that if the case does proceed in Ontario, how might Canadian copyright law differ from the US fair use law when it comes to training AI on news content?
We have a slightly different regime, which is fair dealing versus fair use. And so the two approaches, the Canadian approach and the American approach, are slightly different. In Canada, we have a closed set of categories, whereas in the US, we have an open set of categories that are a little bit more flexible. So in Canada, the acceptable categories of fair dealing include research, private study, education, parody, satire, criticism, review, news reporting. In the US, the court looks at suggestive or illustrative categories like criticism, comment, news reporting, teaching, scholarship, research. So not so completely different, but because the courts are approaching, or the test is structured differently, you could very well end up with a different result. So in Canada, we look at, when we're asking whether or not there is fair dealing, there are 5 elements that are considered: the purpose and character of the dealing, the amount of the dealing, so the amount that's being used, the nature of the work, the availability of alternatives to this so-called infringement, and the effect of the dealing on the market for the original work. I think that's the type of factor that would weigh in, I would think, heavily in this case for a Canadian court, because you would want to be protected. In America, you look at questions like, and again, they're similar but slightly different: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used. I'm using the language that comes out of the case law. And then US law has different concepts that we don't have here, like the concept of transformative use. So whether the so-called infringing work somehow is a transformative use, it transforms or changes the nature of the underlying work. So difficult to understand ultimately where we're going to end up if the Canadian court does take jurisdiction. But I would think some of these factors may militate in favor of the court finding infringement. At least, certainly, I would think that from a protective standpoint, the court will be probably trying to find that result or get to that result.
And finally, we touched on what precedent this could set for Canadian media.
It's going to be really important, I think, for many reasons, but for two reasons that jumped out at me mostly. It's going to address how these digital resources like OpenAI are that are learning or by scraping or ingesting, taking works that are produced in Canada uh, and how they're supposed to be governed. I mean, that's really the main question. And this is an evergreen question in a digital age from a copyright perspective, because it is so easy for these resources like an open AI to quote unquote copy these works. And it can be done at a volume and a speed that, prior to this online world, we never saw before. I think the second major impact and issue is that hopefully this should add some better clarity and protection for Canadian online resources. We are, relative to the US and relative to the global market, a relatively small population. And so the amount of work that we're producing, we want to protect. We see that, just within the country in terms of places like Quebec and how they try and protect their own culture within that. So across the country, I think our court regardless of where it lands, is going to be looking very, very carefully at whether and how we can put up proper fences to protect the work that is being created here so that the creators are getting, proper compensation for it.